Let's jump right into this explainer. Today, we're tackling a really fascinating question. How does the written law, literally just ink on the pages of our statute books, actually get brought to life in the real world? We so often think of the law as this rigid, absolute thing, but as we're going to see, applying the law is actually an ongoing, incredibly dynamic art form. To understand why it's so complex, picture this. You're walking up to your local park and you see a sign that plainly says, "No vehicles inside the park." Seems simple enough, right? But wait a second. Does that include a bicycle? What about a baby stroller, a motorized wheelchair, a toy remote control car? Suddenly, a completely simple five-word rule gets incredibly blurry. I mean, who decides what a vehicle actually is in this context and when it might be allowed? This simple little thought experiment perfectly captures the everyday challenge our legal systems face. To answer that, we're going to use this funnel structure. We'll start with decoding the law, look at the machinery of governance, tackle the idea of impossible perfection, define the state, and finally, wrap up with the living law. Okay, part one, decoding the law. Why does interpretation even need to exist in the first place? Well, these everyday ambiguities, like our park sign, they actually stretch all the way up to some of our most complex constitutional rights. Think about modern banking concepts. How do they apply to digital wallets like Paytm, which definitely didn't exist when the banking laws were written? Or look at the Constitution itself. What exactly is the state under Article 12? Or the massive, sweeping concepts of life and liberty in Article 21? These aren't just academic puzzles. Courts are constantly having to decode and update these meanings to actually protect citizens. Moving on to part two, the machinery of governance. To see how these disputes get resolved, let's look at the three pillars running our society. Power is fundamentally divided. You've got the legislature, acting for the people, making the laws, the statutes. Then the executive branch takes those statutes and implements them. But crucially, the judiciary is the one that steps in whenever there's friction. The judiciary interprets the law and determines its actual scope. They're the ultimate referees calling the shots on what the legislature's words actually mean in practice. And looking at this foundational triad, you realize that maintaining law and order relies on absolute clarity. When rules are broken, the consequences can be massive. Anything from a small fine to, well, life in prison. Because the stakes are literally that high, the exact meaning of these statutes has to be flawless to ensure true justice. But here's the thing. Laws are complicated beasts. When courts apply them, judges aren't just skimming a summary. They have to navigate a highly strict, nested hierarchy. They figure out a provision by descending down from the big overarching act, into a specific section, down to a subsection, and finally, right into specific paragraphs or clauses. It is an incredibly granular process of applying specific facts to very specific words. Which brings us to part three, the impossible perfection. Why do judges spend so much time on this if the intent is already written down? It all comes down to this core truth. Perfect drafting is impossible. If we could draft flawless laws, we wouldn't need judges to decode anything. But human language is inherently flawed. Society changes. Totally unforeseen situations just pop up. Because of that, courts must step in. And they do this in two ways, through basic interpretation, finding the literal meaning of the words, and construction, which is actively giving legal effect in drawing conclusions when the literal meaning just doesn't resolve the case in front of them. Legal scholars have debated this necessity for centuries. Salmon defines interpretation as the process by which courts seek to ascertain the meaning of the legislations, but Cross takes it a bit further. He says it's specifically about determining a statute's meaning for the purpose of applying it to the actual situation right in front of the court. It's not about theory, it's about practical application. I absolutely love this visual from Lord Denning in the Seaford Court Estates case. It perfectly captures a judge's gap-filling role. He said, "A judge is not a tailor making a brand new suit. They must not alter the material of which the act is woven. The legislature made the fabric. But when that fabric gets bunched up or doesn't lay flat over a new situation, the judge can, and definitely should, iron out the creases." Building on that tailoring metaphor, the Indian judicial approach sets a really firm boundary here. In the Nathumai case, the standard is explicitly stated. Courts cannot arbitrarily enlarge or shrink a provision beyond its obvious meaning. The interpretation has to carry out the objective without destroying the original intent of the law. You can iron the fabric, but you can't burn it. So let's jump to part four, defining the state, and see how this crease ironing works in a massive real-world scenario. Here's the setup. Article 13 says the state cannot make any law which takes away your fundamental rights. Huge protection, right? But to enforce that, we have to know who exactly the state is. Well, Article 12 defines the state to include other authorities. But here's the wrinkle. It never actually defines what an other authority is. Is it a public university, a state-funded corporation? The courts had to figure it out. Just look at this timeline. Over 3 decades, judicial interpretation single-handedly evolved the scope of the words other authorities. Case by case, the judiciary repeatedly ironed out the creases as society modernized and the government's reach expanded. You can literally see a massive shift here. Back in 1954, in the Santabay case, the court took a super narrow view. A university was not a state. It only meant entities exercising strict sovereign functions. But fast forward to 1967 with the Electricity Board case, and it expanded to include all those engaged in performing sovereign functions. The very next year, the Umish case officially tossed out that old narrow definition entirely. The fabric of the law was stretching. By 1979, with the R.D. Shetty case, the courts realized they needed a concrete system here. So they established these 5 distinct tests to effectively determine if a corporation acts as the state. They look at financial resources, pervasive state control, governmental character, if a government department was transferred into a corporation, and if it enjoys a state monopoly. It's actually a lot like the concept of vicarious liability. Seeing these chronological notes perfectly captures that living, breathing effort by the judges. As society shifted, the courts continuously did the hard work of interpretation and construction to ensure our fundamental rights weren't just bypassed by corporate technicalities. And finally, we reach part 5, the living law. This decades-long evolution is proof that laws are living instruments. By the time we hit the MC Mehe case in 1987, the famous oleum gas case, the interpretation had expanded so much that currently even totally private corporations can fall under Article 12 depending on their function. The judiciary managed to protect citizens against modern corporate entities just by ironing out the creases of a law written decades prior. So this leaves us with a pretty wild realization. We started by debating if a bicycle is a vehicle in a park and ended up figuring out if a private gas company is effectively the government. If perfect drafting is truly impossible, as AI and crazy new technologies evolve, the art of interpreting our statutes is literally never going to be finished, and that necessity is exactly why specific tools were created to guide judges, which leads us perfectly into the specific rules of interpretation we'll cover next time, the literal, golden, and mischief rules. Thanks for joining me on this explainer, and I'll see you in the next one.